Hello, good evening all. Welcome to another video with Pratham Test Prep. This is your host Sushila and we are back again with another video on your legal current affairs. So currently what we will be dealing with is India's new criminal laws. So recently the Union Home Minister introduced 3 new bills in the Lok Sabha to propose a complete overhaul of the country's criminal justice system. Now these 3 bills, they'll be replacing 3 important laws. The laws that are going to be replaced is our Indian Penal Code, the Code of Criminal Procedure and the Indian Evidence Act. And they'll be replaced by the IPC will be replaced by Bharatiya Nyaya Sanhita Bill 2023. The CRPC will be replaced by Bharatiya Nagrik Suraksha Sanhita Bill 2023, and the Evidence Act will be replaced by Bharatiya Sakshya Bill 2023. Now, before we start our discussions, the way we are going to be proceeding with today's video is going to be that we are going to first talk about the laws in place right now. So for example, if you're talking about Bharatiya Nyaya Sanhita Bill, first we'll discuss about the Indian Penal Code, and then we'll come to the amendments that have been suggested in the Bharatiya Nyaya Sanhita Bill. Alright, so we'll start with the Indian Penal Code. So the Indian Penal Code is a comprehensive legal code that defines and categorizes various criminal offences in India. It serves as a primary law governing criminal conduct and provides guidelines for the investigation and punishment of the crime. Now some key points about Indian Penal Code, like we can see, it was enacted in 1860. So it was enacted during the British colonial period under the guidance of Thomas Babington Macaulay, and it applies to the whole of India. Now the IPC categorizes offences in wide range, so basically deals with a wide range of criminal offences, including those against person, property, public order, morality, decency, religion and the state itself. Now if we talk about the structure of the Indian Penal Code, it is divided into chapters and sections addressing specific types of offences. It also provides definitions of various crimes, outlining their elements and essential components. The IPC also prescribes punishments for these offences that can include imprisonment, fine or both. The severity of the punishment in Indian Penal Code varies on the basis of nature and gravity of the offences. Now if we talk about the principle that IPC is based on, so IPC is based on principles of legality and presumption of innocence until proven guilty. Hence it provides guidelines interpreting the law, establishing criminal liability and determining appropriate punishment. So if we talk about what are the landmark or very famous offences that are dealt in IPC, it includes murder, culpable homicide, rape, theft, robbery, dacoity, extortion, cheating, forgery and many more. And if we talk about the criminal responsibility, the IPC outlines how a criminal will be held responsible. It includes factors such as intention, knowledge and consent, and it also recognizes at the same time various defenses which can be used as self-defense. So the self-defense of private defense, insanity, mistake, necessity. The IPC also addresses situations where multiple individuals are involved in committing of an offence. So that basically talks about the joint liability and the common intention. And like we know, over time with the change in society, IPC has undergone many amendments to address the contemporary issues and changing social norms of our country. And some provisions over time have been modified, repealed, aligned with modern legal perspective. So in summary, if we say the Indian Penal Code is a crucial legal document that defines and classifies criminal offences in India, and it provides, its provision have evolved over time to address changes in the changing society while upholding the principles of justice and legality. Now we talk about the bill that would be replacing it. It is called Bharatiya Nyaya Sanhita Bill 2023. So Bharatiya Nyaya Sanhita bill was introduced in the Lok Sabha on August 11, 2023, and it aims to reform the criminal justice system in India by replacing Indian Penal Code. So this new bill, it addresses a wide range of criminal offences and introduces significant changes to the existing legal framework. The proposed bill maintains certain elements of the existing IPC while incorporating certain other notable changes. These modifications that are proposed, they encompass addition of organized crime, terrorism offenses, strengthening of penalty, inclusion of a new type of punishment, and this type of punishment is called community service. So basically this new bill also introduces community service as a punitive measure for certain minor transgressions. Notably, the bill amends certain IPC provisions that have been invalidated and modified by the courts in their judicial rulings. Now, these would include your adultery and consensual same-sex intercourse as exemplified in the section 377 of the Indian Penal Code. Now, let's see at particular key highlights or key features of this bill. So, first of all, we see removal of sedition. The bill eliminates the offense of sedition as defined in the IPC. So basically the IPC defines sedition as bringing or attempting to bring hatred or contempt or exciting disaffection towards government. It is punishable with the term of 3 years and life imprisonment and or a fine. So either a fine would be imposed or not. Instead, so in the new bill, the new bill introduces new offences related to secession, armed rebellion, subversive activities, promoting separatist sentiments, and endangering national sovereignty or unity. Now these offences, these new offences, they will carry penalties of up to 7 years life imprisonment or life imprisonment along with fines. A new thing that has been added in with this bill is terrorism. So the new bill, in the context of the bill, terrorism is defined as a deliberate act with the intention to jeopardize the nation's unity, integrity, security, while also causing intimidation among the general public or disrupting public order. Now this includes actions such as deploying firearms, firearm explosives, or hazardous substances like biological or chemical agents, resulting in loss of life, endangering of life, or spreading fear amongst the citizens. Additionally, acts involving property destructions, disruption of essential services, and other activities that have been outlined and listed in the listed in the second schedule of the Unlawful Activities Prevention Act 1967, like unlawful seizure of aircraft or hostage taking. Now these are also considered terrorist act. The bill also provides for certain punishment in this regard. So for those who attempt or engage in acts of terrorism, the proposed bill introduces severe penalties. In case where a terrorist I'm really apologize for that. So in case where a terrorist act leads to loss of life, the punishment can extend up to death penalty or life imprisonment, and in other instances where there is no fatality but the act still constitute terrorism, the prescribed punishment ranges from the imprisonment lasting 5 years to a life term. Moreover, to act as a deterrent, offenders are also subject to substantial monetary fine with a minimum fine of rupees 5 lakh. The bill also takes, so this was people committing act of terrorism. Now the bill also takes a stringent stance against individuals involved in planning, coordinating and aiding the preparation of terrorist acts. Those found guilty of conspiring, organizing or providing assistance for such activities could face imprisonment ranging from 5 years to life imprisonment. In addition, there would be a fine of again 5 lakh rupees. Now this comprehensive approach underscores the gravity with which the bill addresses the acts of terrorism and their associated elements. The next thing that the bill talks about is organized crime. So the bill defines organized crime as continuous unlawful activity carried out through violence, intimidation or unlawful means for material or financial gain. Now these activities can include kidnapping, extortion, cyber crime, financial scams, and such activities, such organized criminal endeavors can be carried out either individually or jointly by individuals acting on their own or operating as a part of a crime syndicate. Now talking about the punishment for these particular things, in cases where the commission of organized crime leads to death, the prescribed penalties include death penalty or life imprisonment, and for other situations where it does not result to death, or a death does not occur, but the organized criminal activities are still executed, the punishment ranges from an imprisonment of minimum of 5 years to a life imprisonment. Additionally, offenders are also liable to pay monetary fine, which further emphasizes the severity with which the bill addresses the issue of organized crime. Now, talking about murder based on caste and race. So the bill also, before we move on to that, there is a small thing. The bill also talks about petty organized crimes. So petty organized crimes, in this the bill introduces penalties for attempting or committing petty organized crimes such as pickpocketing, snatching or theft, which creates a general sense of insecurity among the citizens. The perpetrators of petty organized crimes can face imprisonment between 1 and 7 years plus fine. So now let's move on to the next feature of the bill, that is murder based on the caste or race. So the bill introduces separate penalties for murders committed by a group of 5 or more individuals on the basis of caste, race, birthplace, language or personal belief. The offenders in this scenario will face imprisonment ranging from 7 years to life, and even can be awarded a death penalty along with fines. Now, death penalty for gang rape of minors, the bill extends, so initially if we talk about in IPC, the death penalty was, the existing provision was that only in case that the victim is 12 years or lesser, there will be a death penalty for a gang rape. But what the bill penalizes sexual intercourse with a woman not amounting, so the bill basically extends the death penalty to instances of gang rape involving victim below age of 18. Initially in the original IPC it is age of 12. Now let's talk about the next key feature that the bill talks about. It is sexual intercourse by deceitful means. So the bill penalizes sexual intercourse with a woman not amounting to rape achieved through deceitful means or on the pretext of false promise of marriage without the intention of fulfilling it. The offenders in this particular scenario can face imprisonment up to 10 years as well as fine. Lastly, extending applicability of certain offences to boys. So the bill expands the scope of offences related to illicit intercourse by making it a crime to import boys under the age of 18 for such purposes. If we talk about what was the scenario in the IPC, under the IPC, only importing women under the age of 21 for illicit intercourse with another person was considered as an offence. So in summary, if we see the Bharatiya Nyaya Sanhita Bill 2023, which replaces IPC with a more modern and comprehensive legal framework, and it addresses various criminal offences and introduces new penalties and definitions to align with the contemporary social issues that we are facing right now. Alright, now the next bill that we will be talking about is the bill that replaces the Code of Criminal Procedure. So the Code of Criminal Procedure, also commonly known as the CRPC, is a comprehensive legal code that governs the procedures involved in criminal cases, and it outlines the process related to investigation, arrest, prosecution, trial, appeal. And if we talk about the certain important things about CRPC, it provides a framework from the beginning till the final disposal. So from filing of the FIR to the final disposal, it is there. We can see IPC was, the Code of Criminal Procedure was enacted post-independence. It was enacted in 1973. Alright, and it applies to the whole of India. It outlines conditions under which a person can be arrested, the procedure of the arrest, the right of the person who has been arrested. It also establishes provisions of bail. It gives guidelines regarding the investigation of a crime, including the search and seizure procedures, and also defines the duties and the responsibilities of the police officers as well as the magistrate dealing with such cases. The CRPC defines the procedures of conducting trials in criminal cases, including framing of charges, examination of witnesses, recording of evidence, cross-examination, to ensure that the trial is fair and transparent. So all these procedures regarding all the criminal trials are given in CRPC. So it also further, if we talk about, it also gives guidelines regarding the pronouncement of the judgment in criminal cases and determination of sentences, so that it ensures that the judgments are well reasoned. It also provides for the role of magistrate and issuance of warrants, summons to compel the attendance of a witness to the to court. So all in all, if we see that in summary, CRPC is a critical legal document that establishes procedure of investigation, prosecution, trial and appeal in criminal cases in the whole of India, to ensure fair and transparent process. All right. Now let's talk about the bill that is going to be replacing it, that is called Bharatiya Nagrik Suraksha Sanhita Bill. Now the bill was introduced in Lok Sabha on August 11, 2023, and it aims to replace the CRPC, which governs the procedure of arrest, prosecution and bail. All right. The bill, unlike IPC, the bill retains most of the provisions of CRPC. Let's get into what exactly are the key features of this bill this time. So, detention of under trials. So, under the code, if an accused has spent half of the maximum imprisonment duration in the detention during investigation or trial, they must be released on a personal bond. But there have been exceptions given in this particular scenario, where the punishments which are offences which are punishable by death. The current bill, it expands this exception to include punishable with offences punishable with life imprisonment and individuals with proceedings pending for multiple offences. The bill also gives a special provision for first time offenders, which says that the first time offenders can be released on bail after serving 1/3 of the maximum possible imprisonment, with the jail superintendent initiating the bail application. Now let's talk about the trial procedure. There are two things that have been talked about here. Trials in electronic mode. So the bill permits all trials, inquiries and proceedings to be conducted electronically. Electronic communication devices that may contain digital evidence can be produced for investigation, inquiry or trial, encompassing devices such as mobile phones, computers and telephones. Secondly, it talks about trial in absence of the offender. So in the bill allows trial and judgment to proceed, pronouncement of judgment to proceed in absence of the proclaimed offender who has absconded to evade trial, provided that the person is accused of an offence punishable by at least 10 years. So proclaimed offender is an individual accused of a crime carrying punishment of at least 10 years, or the one who fails to appear at a designated time and location as ordered by court. Now talking about the medical examination of the accused, so in CRPC only a police officer who held the rank of sub-inspector could request for medical examination of the accused, but that has been changed in the current bill. Any police officer can ask for a medical examination of the accused. Now coming to the forensic investigation, the bill mandates forensic investigation for offences punishable by at least 7 years of imprisonment. Forensic experts will collect evidence from the crime scenes, recording the process they will collect, and while collecting they will have to record all of this, their procedure on an electronic devices, and states which do not have forensic facilities can utilize those in the other states. Now talking about the prohibition, the next key feature, prohibition of carrying arms. The provision allowing, so CRPC confers authority upon district magistrate to forbid the possession of weapons during public procession, mass drill, group training involving arms in public spaces, with upholding the public peace and safety as a reason for not allowing. These restrictions can remain effective for the period of to 6 months. But one thing there is to be noted here, that although this provision was included in the code, it has never been enacted. So hence the provision has been omitted from the new bill. Now talking about the signature, finger impression and voice samples, the bill expands the power of metropolitan or judicial magistrate to order the provision of specimen signatures, handwriting, finger impression, voice samples for investigation or proceedings, even from those not yet arrested. In CRPC, the judicial magistrate or the metropolitan magistrate could only direct individuals who have been arrested in connection of the investigation. But in the new bill, there is that change, that even the people who have not been arrested, we can be asked to provide a sample of their signature, finger impression or voice samples. Now the bill also prescribes certain timeline for some procedures. So the bill introduces specific timelines in procedures such as submitting a medical report on rape victim. So within 7 days of the offense, the medical report of a rape victim has to be submitted. The judgment has to be delivered in a particular case, has to be delivered within 30 days, which is extendable up to 60 days. Informing victims of investigation progress should be done within 90 days of the investigation starting, and framing of charges should be done within 60 days of the first hearing. Now this was all about the new bill which is going to be replacing CRPC. So Bharatiya Nagrik Suraksha Sanhita 2023, which replaces the old CRPC 1973. It has modernized in a way in conducting criminal procedures such as like introduction of electronic modes, forensic investigation, timeline for procedures. Now let's talk about the last bill, the last key bill that was introduced. So that particular bill that we'll be talking about replaced Indian Evidence Act 1872. So again 1872, that means that we know that it was enacted during the British colonial period, and it is based on the principles of English common law, aimed to establish a uniform approach to evidence across the diverse legal systems in the country. The act defines evidence, it categorizes evidence also in various forms. It categorizes evidences as oral, documentary, electronic, primary, secondary. So we'll get into that also. So the act, it defines evidence which is relevant, outlines principles of determining relevancy and how these such evidence will be admitted, and what will be the gravity with which these particular evidences will be taken into consideration. So while looking at Indian Evidence Act, there are certain things that we need to know. So for example, now let's talk about types of evidence. So the act distinguishes between primary and secondary evidence. So primary evidence basically includes original documents, whereas secondary evidence refers to copies or reproduction of that document. So always the primary evidence will be given more value than the secondary evidence. In witness testimonies also, that how a witness is supposed to testify in the court, the act includes the hearsay rule. So the hearsay rule, which basically says that hearsay evidence cannot be used as a proof. So basically statements made by someone who was not present at the crime scene but heard somebody say something, so those would be considered hearsay evidence. Those would not be included. Privileged communication, so the Indian Evidence Act recognizes certain communications as privileged, and therefore these privileged communication are protected from being admitted into court as evidence. So these communication will include between legal advisors and clients, husband and wife and others. Similarly, the opinions of the expert would be considered as a secondary evidence. So this is all given in Indian Evidence Act. We can get into depth as much as we want. The act also includes doctrine of estoppel. So here it is very important to note that the doctrine of estoppel here prevents a person from denying a fact from asserting a claim inconsistent with their prior conduct or statements. All right, now let's go ahead and talk about Bharatiya Sakshya Bill 2023. So this is the bill which aims to replace the Indian Evidence Act. So it was introduced on August 11, 2023, and it aims to replace the Indian Evidence Act of 1872. So the Indian Evidence Act, like we have discussed, it establishes standards for the admissibility of evidence in legal proceedings, and it also governs criteria of acceptance of evidence in legal proceedings. Now, let's talk about the bill now. While the bill preserves certain components of the original act, but it also makes some notable changes, and these modifications involve eliminating colonial references, expanding the scope of permissible electronic records as evidence, and omitting provisions relating to telegraphic messages. Now let's see what are the key features of this particular bill. Now, what does the bill say about admissibility of electronic records? So the bill introduced the inclusion of electronic and digital records as evidence alongside existing categories of documentary and oral evidences. It expands the scope of admissible electronic records to include information stored in semiconductor memories and various communication devices such as laptops and smartphones. Now this encompasses records from email, server, logs, locational data, voicemails and more. The bill also clarifies that electronic records may be created, stored or processed through one or more computers or communication devices, either standalone or as a part of a network, which may or may not involve intermediaries. Now, coming to the oral evidence, if we see under the Act, oral evidence includes statement made before court by witness in relation of a fact under inquiry. So what this bill changes here, the bill extends the concept of oral evidence and to include information provided electronically as well. Now the bill also broadens the category of secondary evidence to encompass written or oral admissions as well as the testimony of an expert skilled in document examination. Under the Act, secondary evidence may be required when originals is in possession of the opposing party or have been destroyed. But now the bill extends this requirement to instances where the authenticity of the original document itself is in question. At that moment, the secondary evidence will be given more value. Production. Now, regarding production of documents, the bill reaffirms the provision of production of documents. So under the Indian Evidence Act, when a summoned witness possesses a document and is directed to present it, they must do it in a court even if the objection about its admissibility arise, because the court holds the authority to assess the document's authenticity. Now what has changed here in this particular bill, that the bill has introduced an exception that the privileged communication between minister and the president cannot be compelled for a production before a court. Now lastly, the bill talks about joint trials. So the bill addresses joint trials by explaining that if one accused person's confession affects others, it will be treated as a confession against all in a joint trial, and additionally a trial involving multiple accused where one has absconded or not responded to an arrest warrant will be considered a joint trial as well. Now in a sense, if we see all these bills, more or less they help our criminal justice system in achieving and in being contemporary with what is happening in the world right now and what is happening in our country right now. So the bills have been a very welcome change for all because it improves the criminal justice system according to what is relevant in the society for today. Thank you so much for watching our video. Please like, comment and share if you really like the video, and subscribe subscribe to the channel for more such educational videos. Thank you so much. Have a great day.